The Act of Settlement, again, this was passed in 1701. I won't go into details on it, but there it is. That was the original one. Cabinet members or privy councillors, they all swear oaths of office. Again, I'll come back to that in a little while. Parliamentary Code of Conduct. Well, we're now all knowing that we've got Parliamentary Code of Conduct for our MPs. So what happens to the MPs? Well, their Code of Conduct. MPs' public duty. By virtue of the oath or affirmation of allegiance taken by all members when they are elected to the House. And remember that to be in the House, they have to swear an oath of allegiance. Well, that allegiance is not really doff cap to your Majesty quite. It's doff cap to the people and to the power of our Constitution. That's what the majesty of the Crown is all about, and that's where this really resides. But there's a lot of mileage in saying, oh, it's all doff cap to the royalty and all the rest of it. So, by virtue of the oath or affirmation of allegiance taken by all members when they are elected to the House, members have a duty to be faithful and bear true allegiance to Her Majesty the Queen, her heirs and successors according to law. Members have a duty to uphold the law and to act on all occasions in accordance with the public trust placed in them. Well, quite evidently, the public trust we place in our MPs is to abide by the rules of our constitutional law in order that we can be governed for our liberty, because that is the purpose of the Constitution. It took me nearly 10 letters to get out of the Lord Chancellor's office this. I would agree that we are all subject to the rule of law and that this is a fundamental and an essential principle of democracy. As I tried asking them, I said, well, do you think you say you can do anything you like? Well, could you repeal the rule of law itself and put in place a dictatorship? Because that's the ultimate goal if you can govern everything. And of course, eventually, I cornered them into that reply. So what you're learning now is that Constitution ought at least to be all-powerful. Parliament is only a component under the Constitution. It's a subordinate component of it. It's the law-making body of the Constitution. Our Constitution does not empower Parliament with unlimited or absolute power. Well, clearly the Queen shouldn't breach things that go against the terms of her coronation oath. And therefore, ministers, if they can't advise its breach, again, you can see how it all contracts down and starts to create limitation. Upholding our Constitution is the preeminent public duty of all who hold office. Well, of course, that must be the preeminent duty. And it should obviously, therefore, always be their certain policy. Well, we know that that part has fallen to pieces. And indeed, they've done some downright opposing things. The people's liberty is ultimately upheld at the discretion of our juries. And there was a very interesting case on this. Perverse verdicts, the ultimate common law proof as to the limitation of statute power. A jury may never be directed to give a guilty verdict. Now, just to show you how far things have gone, there was a chap called Wang who I think in 2002, 2003 was having a pee in a railway station, and he had his bag mugged from him. And the chap picked the wrong bloke because Mr. Wang just sorted himself out and grabbed his phone and chased after the mugger who he saw ducking round the end of the platform somewhere, caught up with him. And by that time he'd managed to get the emergency services on the phone and call for the police. And the mugger had just unzipped the bag and found a samurai sword in the bag and said, well, you won't be calling the police, will you, because you've got an edged weapon in a public place. And Wang said, well, I'm having none of that. And, of course, the police came, and we know what would happen. Of course, they arrested both of them, and indeed, Mr. Wang got taken to court. And the judge, this is the absolutely incredible bit of this case, the judge said, oh, yes, that's a regulatory thing, you're guilty, and told the jury that he was guilty. So that was the direction. And, of course, it was appealed, and it was appealed into the House of Lords, and there was a unanimous verdict in which Bingham gave judgment, and the Lords, bless them, said we can consider that there are no circumstances in which a judge may direct a jury as to somebody's guilt. Now, this is terribly important because technically, Mr. Ponting, if you remember the secrets case in the late 90s when he blew the gaff on Home Office cover-up or whatever about secrecy laws, Ponting was taken to trial. And undoubtedly he'd broken the Official Secrets Act. But the jury gave a not guilty verdict. Now that is the real strength of jury power, and it protects you, me, and all of us in this nation from oppressive measures. So the jury is a common law council of whether it thinks a measure is oppressive or not. Generally, of course, if a felon is brought before the court and he's done something wrong, a jury will be as shocked as ever. But in Ponting's case, they took the view that what he was doing was entirely within the letter of the law, and it might well be that the person who blew the gaff on the MP's expenses, I don't suppose they'd even dare take him to court, but if they did, I don't think you'll find a jury in the land that would convict him, although technically he may well have breached the law. But this is jury power. We need it. We need to be absolutely glued to it and not allow any prizing of it out of our hands. To go the other way, to see what happens when autocratic power takes hold, Henry VIII, and this is the earliest document that I've handled as such, had an act against poisoning back in 1531. And he thought that poisoning was a particularly dastardly thing to do. And the Bishop of Rochester's cook, one Richard Rose, had poisoned the staff in the palace and tried to poison the bishop himself. And one Alice Trippitt is recorded on here as dying, and it says it's a bit unclear because it talks about 17 being mortally affected. So I don't know whether it kills 17 people or not, but it actually only declares poor Alice Trippitt as having died. Anyway, that is the power of these bits of paper or parchment. This act was an act against poisoning, and what did it do? Henry VIII wanted to set an example, so poor old Richard Rose shall therefore be boiled to death. And indeed he was boiled to death, and I'm able to confirm that in some other parliamentary books that I have, which were printed in the 1750s. Hall mentions another act, that those who poisoned any person should be put into hot water and boiled to death. This act was made, adds he, because one Richard Rose in the Parliament time had poisoned divers persons in the Bishop of Rochester's palace, for which fact he was duly boiled to death in Smithfields. So that makes you think about it a bit, doesn't it? It brings a bit of reality to this. Now then, excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. That is one of the 13 clauses and the remedy, or rather, for one of the wrongs that James was about. And that is in the Declaration of Rights, and of course it is therefore in the Bill of Rights. That excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Well, cruel punishments did go on, and they went on for much longer into Nelson's Navy. I think we had, or certainly had floggings much more recently, but keel hauling, which was a particularly nasty punishment, but it was the usual naval punishment for certain crimes. So what this clause did is it had a civilizing influence, and by and large I think it stopped the hang-drawing and quarterings, which were very grotesque business for those who committed treason. If you ask the man in the street, what about Constitution? Generally we get, oh, well, we don't have one, but the Americans have got one. So let's have a look at the American Constitution, because didn't they use exactly the same principles as we did? A lot of them, after all, were Englishmen who had gone fed up here and didn't like paying too much tax, so they went abroad. And, they had their Bill of Rights, and here it is. And the whole thing is built on exactly the same thing. It's principles written down, known and declared beforehand, which is called law, written law, statute law, and oaths of office and honour to bind this whole lot together so that they shall be obeyed. And, of course, that there's means of redress and remedy in event that they go astray. And interestingly, not only did the Americans make their Bill of Rights, they actually copied bits of it word for word from our own. And so here you can see excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And there it is, as article, the 10th article. And those words, of course, come directly from our Bill of Rights. So everyone talks about having a Bill of Rights and the American Bill of Rights and all the rest of it. Well, actually, we've got the granddaddy. There he is. And it's a tremendous document, and it's very powerful indeed, in my view at least.